This is Jennifer Wilson, and I have prepared a storyboard to illustrate my fact pattern for this week, addressing the issue of conflict of interest. In my story, Mr. Moneybags was a wealthy older gentleman who died, leaving a wife to whom he'd been married for 11 years and two adult children from his first marriage. Early into his second marriage, Mr. Moneybags had met with Mr. Ira Local, who was an attorney there with whom he had dealt before, and had a will prepared. And he named his wife as executrix under the will. In his will, Mr. Moneybags provided for the payment of all of his funeral and burial expenses and to make sure that any outstanding debts that he had would also get paid. He then specifically directed that $250,000 be paid to Mrs. Moneybags. He left the remainder of his estate, or his residual estate, to his two adult children to share equally. When all the assets of the estate were marshaled, it was determined that Mr. Moneybags' estate was worth more than $2 million. Under Tennessee Code Annotated 314101, which is the elective share statutes, the surviving spouse in an intestate estate, or in even an estate where there is a will, has the right to elect against the will and get a share based on how long the parties were married, if they feel that that amount is more than what they would receive under what the will itself leaves them. So in our instance, Mr. and Miss Moneybags had been married for 11 years. So under the statute, it's possible that Mrs. Moneybags could get up to 40% of Mr. Moneybags' net estate. So Mrs. Moneybags contacted Mr. Local, knew that he had prepared the will, knew that he knew the family, and had a history with the family and the assets and the business of the family, and asked him to probate the will. Mr. Local, knowing what he did know about the family and having prepared the will, advised Mrs. Moneybags that she herself should seek her own counsel to advise her of any of the rights she had as a surviving spouse. He also advised the adult children that they should talk to an attorney on their own so that they could understand what's going on, considering they were residual beneficiaries. And of course, the more money Mrs. Moneybags gets from the estate, that comes from the children's residual estate side. So Mr. Local recognized that he had a conflict of interest as far as he could not represent the estate and represent Mrs. Moneybags, and he knew she would have some rights under the statute. So he advised her to go, or advised all of them to go, that they should check with other attorneys on what they should do. Mr. Local was able to continue to serve as the attorney for the estate, because the attorney for the estate simply administers the estate based on the direction of the will, or in this case, possibly the statute or a court order, an agreement, whatever the parties come to. So he was able to protect himself against any claim of conflict of interest or the appearance of any impropriety as such by telling the parties up front to contact other attorneys for themselves. And that's my story. Thank you for listening.